May it please the Court, David Rosenberg on behalf of the appellee, U.S. Bank. If this Court has no immediate questions, I guess I'll just go briefly into my argument regarding the demand letter.
If you wish.
So the March 13th, 2013 demand letter substantially complied with paragraph 22 of the mortgage. Our letter reminded the borrower to make any additional payments that might come due within 30 days from the date of the letter, in addition to paying the $1,900 that was due in order to cure the default. It is undisputed on appeal that the letter correctly listed that $1,900. Falgoust never disputed that he knew he had to pay $1,900. He never disputed that he knew he had to pay the April 1st mortgage payment that came due within 30 days from the date of the letter. Instead, he testified at trial that he was apparently so confused about what additional amounts meant that he paid neither the $1,900 nor the April 1st mortgage payment, nor any mortgage payment over the last 6 years since February 1st, 2013. In Dopker, which Judge Casanueva, Judge Silberman, you were on that panel, this court found a letter to be substantially compliant, where it required the borrower to make any payments which may subsequently accrue on or before the cure date, in addition to the amount required to cure the default. There is no material difference between the letter in Dopker and the letter here. In Dopker, this court also cited Diaz from the 5th DCA and Cadet from the 3rd DCA. The language in Diaz and Cadet was not materially different from the language in this letter. Those courts likewise found those letters to be substantially compliant with the terms of the mortgage. As this court held in Malam, paragraph 22 is designed to ensure that a borrower receives essential information concerning his or her default, how to cure it, and his or her rights with respect to it. It is not a technical trap designed to forestall a lender from prosecuting an otherwise proper foreclosure action because the borrower decided after the fact that the letter might have been better worded. So for those reasons, we submit that the letter is substantially compliant, at least with paragraph 22 of the mortgage. The second thing I'd like to turn to, if this court has no questions on that, is the phone call. Now, assuming the letter, which we contend is substantially compliant with the terms of the mortgage, the phone call is irrelevant. All that Falgoust challenged on appeal was the sufficiency of the letter. If the letter is substantially compliant, the phone call is irrelevant. It is not related to conditions precedent. We are not required before foreclosing to speak to Mr. Falgoust on the phone about the contents of the letter. It is not part of his affirmative defense. So, with that said, regarding the phone call, it does not contradict the letter. At no point did the people that he spoke with tell him to pay a different amount. At no point did they tell him that he could not pay the $1,900 that was listed in the letter. At no point did they tell him he did not have to make his April 1st mortgage payment, which came due within 30 days from the date of the letter. At no point did they tell him that he did not have to make any of his mortgage payments over the last 6 years, which he has not made. I'd also note this was testimony. There were lots of discrepancies in his testimony. He was recalling conversations he had with unnamed people on unnamed dates about 4 years prior. He couldn't recount exactly what was said to him. He used words seem, kind of, maybe, I think. It's unclear exactly what he asked the people he spoke with. It's unclear exactly what their answers were. Really, what the letter stands for is just that he had conversations, what the phone call stands for is just that he had conversations with these unnamed people 4 years ago. There was confusion, potentially, this is best case scenario, confusion, potentially, regarding what they were telling him, and confusion on their part, apparently, as to what he was asking him. He apparently was asking them, do I have any additional charges to pay? In my mind, reading over his testimony and what he was recounting, which was hearsay, of course, but what he was recounting, they said to him, they were saying, essentially, no, you don't have any, we don't know what the additional charges are, we're not sure what's going on there, you don't have anything else to pay. They never sent him another letter containing additional amounts to pay. They never told him again that he didn't have to make the $1,900 payment and that he didn't have to make his April 1st payment, yet he didn't make those. Really, what this comes down to is this is testimonial evidence. Under Blackwood, under this court's decision in Savage, this court cannot reweigh testimonial evidence. So what this court is doing is it's just looking at was there legally sufficient evidence to support the trial court's decision, not whether it could have reached a different conclusion based on the evidence before it. We submit that there's competent substantial evidence, legally sufficient evidence in the record to support the trial court's decision. The final thing I'll note is that we also argued that Falgoust argument, portions of it at least, were unpreserved for appellate review. He did not file a reply. He did not contest that. Those are the main points. If this court has no further questions, as I said, I'll keep it short.
Nice job.
Thank you, Honor.
Thank you, Mr.
Difficult.
Rosenberg.
Safe travel.
Yeah.